Hi, everyone. We're just waiting for participants to keep flowing in, and we'll get started in just a few moments. Okay, we'll get rolling with the event today. Welcome, everyone. I'm so happy to have you here. I'm Allison Fenske. I'm a staff lawyer with the Public Interest Law Center. I want to start today's event off by acknowledging that Manitoba exists on the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. The Public Interest Law Center, and many of you joining us here today are in Winnipeg and are located in and working from Treaty 1 territory. I also want to acknowledge that for those of us in Winnipeg, our water is sourced from Shoal Lake 40 First Nation in Treaty 3 territory. While we're looking forward to a positive discussion around the value of public interest legal work, I think I would be remiss if I did not also acknowledge that efforts toward colonization and the continued dispossession of Indigenous lands and resources have often been framed as being within the public interest. So I would invite you to join me in reflecting on what is the public interest and what actions can we take to work towards redress in an otherwise impoverished view of it. And so I hope today's event can help in aiding that action of reflection. I'd like to introduce you to the Public Interest Law Center for those of you that may not be familiar. The Public Interest Law Center is an evidence-based, nonpartisan legal center with 4 decades of service aimed at amplifying the voices of the most historically disadvantaged people in our community. We are an Office of Legal Aid Manitoba, serving persons and communities who face systemic barriers to full participation in our society. As part of our public interest mandate, we run the Pro Bono Public Interest Law Project, which is a joint venture between the Manitoba Bar Association and PILC. Launched in 1996, the project encourages lawyers and law firms to donate professional time or funds to enhance access to public interest legal services in Manitoba. We're very excited to be hosting today's discussion about public interest work aimed at articling students and early career lawyers at private firms, curious about how to incorporate giving back into their developing practice. I do have a few logistics to go through before we can introduce today's speakers. We are presenting this using Zoom's webinar format, so that means only speakers will be visible on the screen. We do want to keep things to a kind of informal discussion, hope that people can connect. So while our moderator, Chim, will be kicking off the discussion, one way to keep things interactive is to make use of the question and answer box. So there'll be a button below on the bottom of your screen, Q&A. Please type in any questions that you have so that we can try and cover off as many as possible in the time that we have together today. The event is being recorded for those who aren't able to attend live at this time, and a link will be sent out later. Closed captioning is also being provided for this event by National Captioning Canada. So on that same menu on the bottom of your screen, you should see a CC button, that CC live transcript. That's where you can access closed captions. There should also be an option to see the full transcript alongside your screen if you prefer. So turning now then to the introductions of our speakers. First, our moderator, Chim Undi. And I'll welcome Chim to the screen. Chim is currently articling with TDS and is a rising star in Manitoba's legal community. Previously, as a summer student here with PILC, she made important contributions in advocacy work around the Vulnerable Persons Act, as well as with respect to the human rights of non-binary Manitobans. In addition to having exciting things ahead of her in her legal career, Chim is also an accomplished poet and spoken word artist whose work encompasses a number of themes, including social justice. Welcome, Chim.
Thanks, Al.
Thanks. All of our panelists are accomplished lawyers in their own right, and each has made important contributions in the public interest through pro bono work. In introducing each speaker, I want to take the opportunity to highlight just one of the important contributions they've made. So first, we'll welcome Christian Monen from Mlt Aikens. Christian is a member of the advocacy group at Mlt Aikens. He has been recognized for his work on behalf of the Assembly of Manitoba Chiefs, an intervener in the Conseil scolaire francophone de la Colombie-Britannique v. British Columbia education, an appeal which involved French language rights in education. At issue is whether the province of British Columbia's underfunding of French language schools was a violation of constitutionally guaranteed rights to minority language education. The case was heard in person in Winnipeg, representing the first time that the Supreme Court sat outside of Ottawa in its then 144-year history. Thanks for joining us today, Christian.
Happy to be here.
Next, we have Dana Steinfeld. Dana is a litigator with Fillmore Riley. In 2020, she was recognized for her role in an intervention before the Supreme Court of Canada in the case of R.V. Lee. In this case, Dana acted as co-counsel for a coalition, which included the Aboriginal Council of Winnipeg, Canada Without Poverty, Canadian Mental Health Association, Manitoba and Winnipeg, and End Homelessness Winnipeg. This case dealt with questions of privacy rights connected to property, police intrusions, and whether a privacy interest premised on control of property can be meaningful for individuals who lack the resources and often the authority to proactively secure their own dignity. Thanks for joining us today, Dana.
Thanks for having me.
Next, we have Kathleen Mccandless. Kathleen is a litigator with Pip-Lado. She was part of a team of lawyers recognized in 2019 for their significant contributions to matters relating to social inclusion for persons with disabilities. Kathleen provided assistance to Barrier Free Manitoba, a nonpartisan, nonprofit cross-disability initiative, and its advocacy for the disability community relating to the Accessibility for Manitobans Act. We will also have Robin Kazina joining us hopefully a little later. Robin is joining us a little later in the conversation today because she's an in-demand expert in fertility and surrogacy law. So we're sharing her today with the Canadian Bar Association. Robin was recently co-counsel on a successful constitutional challenge to Manitoba's legal parentage laws under the Family Maintenance Act, which discriminated against LGBTQ2S parents who rely on reproductive technologies. As a result of this significant victory, Manitoba will be amending their legal parentage laws so that any family who uses assisted reproduction has a meaningful and accessible pathway to legal recognition as parents. So we'll look forward to Robin joining us. And last but not least, Sasha Paul from TDS. Sasha practices primarily in two areas of law, Aboriginal law and public administrative law. Sasha was lead counsel in a notable pro bono intervention for Amnesty International in the case of Canada v. Cotter, respecting Section 7 life, liberty, and security of the person rights under the Charter. And he's also been recognized for his work on behalf of the Council for Canadians with Disabilities in their intervention before the Supreme Court of Canada in Delta Airlines and Gabor Lukash, a case which considered the appropriate criteria for deciding whether to hear complaints before administrative bodies such as the Canadian Transportation Agency. So without further ado, I will turn things over to Chim and we'll have what I hope to be a really great discussion with all of our esteemed panelists. Thank you all for joining us.
Hi, thank you, Allison, for that really kind introduction. Like you said, my name is Chim Undi. You can call me Chim. I'm articling here at TDS on Treaty 1, and I'm really excited to be facilitating this conversation, especially after hearing those really interesting introductions to some of the work that you folks have taken on. I'll be taking, or Allison will be passing on any questions that people might have in the chat with respect to how folks who are early in their career, like myself, can develop a practice that incorporates giving back through public interest work. So I do have some questions that I've taken from myself and from some of my colleagues who have the same curiosities as I do. Kathleen, I know that you have to leave early today, so maybe we'll start with you. Can you tell us a bit about what interests you about working on public interest files and how you've benefited from working on this kind of work?
Sure. So one of the main reasons why I like working on public interest files is that they tend to give you an opportunity to do something different than your day-to-day. So in the practice of law, it's a business, and you're going to be spending a lot of time thinking about billable hours and a lot of deadlines. You have a very interesting public interest file, and in my view, pretty much everything I've worked on that's pro bono is very interesting. It's an opportunity to sink your teeth into an issue that you probably don't deal with in your day-to-day practice. It obviously also is helping out someone or a group of people that would not normally have access to legal services. So you're providing an invaluable service to people. And third, I think you do because in the practice of law, it's a business, you have to be very efficient in how you spend time because then you're billing your clients for your time. When you have a pro bono matter, you don't have that same constraint. So obviously, subject to juggling all your other priorities, you have to be mindful of how you do that. But you can spend a lot more time really drilling down into issues, and it can be more of an academic exercise than a lot of your day-to-day. So I think that was my answer to the first part of the question, but now I need you to remind me what the second part was.
Fair enough. I was just wondering what kind of benefits you've touched on that a little bit. What kind of benefits have you derived from working on public interest files?
Right. So yeah, in addition to the ability to, I think, really sink your teeth into an issue and gain some academic understanding, obviously you have the benefit of feeling like you're doing something good for the community, and it gives you an opportunity often to get more experience. So earlier on, because often when you're articling and you're in your junior years of practice, you're assisting on files, so you may be doing more research and drafting, but you may not be getting up on your feet in court or dealing one-on-one with clients on your own. If you take on a matter pro bono, that increases the opportunity you have to get into court and get before a judge or be meeting directly with clients early on. So that's a benefit.
It's really interesting. Thank you, Kathleen. Dana, has your experience been similar to that?
Yeah, I would echo much of what Kathleen said. For me, pro bono files are often an opportunity to stay engaged in areas that are of interest to me that don't tend to come up as often in private practice, like complex constitutional issues. I've been lucky in my practice that I have on occasion been able to take on that kind of work in the ordinary course, but doing pro bono work is a great way to stay engaged in those issues, stay on top of them, and think more deeply about them, as Kathleen said. And really, it's a really fulfilling kind of work because you're getting the opportunity to give back, to work with different clients, meeting different clients, getting exposure to different issues, and being really intellectually challenged. So it's fulfilling for me on a number of levels. And I think in that way, it's what interests me and also what benefits me. And for sure, the experience that you gain having an opportunity to take on a bit of a bigger role, even at a more junior stage. For me, I got to be involved in an intervention to the Supreme Court and have my name on a Supreme Court decision with the Lee case that Allison mentioned. And that's really incredible experience that doesn't come along all that often for most lawyers. So the benefits, I think, are huge.
Great, thank you, Dana. Christian, how about you?
Yeah, I'd be part of the Me Too brigade as well. I'd chime in on what Dana and Kathleen said. But for me in particular is, as Kathleen said, private practice is a business and there can be some monotony with that. But for those of you out there who are students or getting into the practice of law, and I don't mean to dissuade you, private practice is very fulfilling, but to be able to work on public interest matters, something that you find to be very interested or something that you hold near and dear to your heart, and the matter that I dealt with had to do with language rights. I am a Francophone. I'm a product of the Franco-Manitoban School Division, and if it wasn't for these types of cases, I probably wouldn't exist in that sense. And so to be able to contribute to case law that has a national importance and national impact is it's very fulfilling. And also the exposure to different lawyers that you probably wouldn't see in your day-to-day practice is something that I find very interesting, very fulfilling. These types of cases bring counsel from across the country, folks that you likely wouldn't see in your day-to-day practice, and you're gonna learn from these folks. You're going to see how these other lawyers, how they practice law, how they work their file, and there's nothing but upside for that. So.
What about you, Sasha? I don't imagine you're going to say that it's been all downsides in doing public interest work.
It's been the worst decision I've ever made in my life. And no, it's been wonderful. It allows me the opportunity to move from, trying to advise clients, you want to do this, and I think you can do it this way, to actually pick cases that are of interest to you. And perhaps I'm too mercenary. Like I accept the fact that when I'm a lawyer, I'm there to do the best I can for my client. And so it is a welcomed opportunity, because I still do this. Like I still monitor every Thursday when the Supremes grant leave to say, I wonder what's that about, or should I get involved in that? Because it allows me to think as myself, as opposed to being a hired gun. I mean, I like being a hired gun, and I also like thinking for myself. But that's what I get out of it, and I enjoy it. Did that answer the question?
That does answer the question, Sasha. A+. I think Kathleen and Dana, you both mentioned the opportunities that are sort of unique, especially for junior lawyers, given that at this stage, most of our experience is sort of shadowing lawyers or more senior lawyers on their files. Can either of you talk about how sort of the logistics of being a junior lawyer and taking on pro bono files when your workload is dictated by other lawyers?
Sure, I can jump in there. I was fairly junior, I guess, when I started working on the Lee file. I mean, I think the first thing, the way that I approach it in terms of perspective is that once you take on a file and you're representing a client, they're your client, and they're no less important than any other client, and you have the same obligations to them that you would to someone who's paying out of their own pocket. And so I think coming at it from that mindset has always allowed me to just manage my time and approach it like an important file with deadlines like any other file, and make sure that I'm giving it the time that it deserves along with all of the other files on my plate. I think importantly, often these files you're not working alone, particularly if you're doing them through the Public Interest Law Center program. And so if you're working on a team, then, and I think this can be hard for juniors to do, but you're an equal member of the team and you should be honest about what commitments you have, what availability you have. My experience working with PILC on a number of files now is that there's always really honest conversations about, who's got the time to take on this particular step. And if I'm able to take something on, then great, because that gives me the experience of drafting that particular document or making that particular argument. If I'm really slammed, I've always felt that I can be honest and say, right now I'm really busy, I can help in this way or that way, but if someone else can take the lead, that would help me out. But hopefully you're doing it because it's an exciting and fun file. And in that sense too, I mean, I'm not going to lie, I have definitely put in weekend work on some of my pro bono files. But because they're files that I'm really excited about and they're issues that I want to be spending time on and thinking about, I don't really mind having to put in a little bit of extra time on a weekend or an evening if need be, because I'm having fun. I guess maybe I'm just a big nerd in that way, but you know, I remember spending a Sunday like really deeply thinking about privacy issues and the Supreme Court privacy jurisprudence on the Lee file and just having the best day. So hopefully the fact that you're enjoying the work makes some of the trickier things about the time management worth it.
Kathleen?
Yeah, I'd echo all of what Dana said. That, I mean, when you're an articling student and a junior lawyer, you're learning time management every day. You're going to find some days that you're very swamped and you don't know how you're going to get things done, but you're going to get them done. So it kind of, in my experience, it just fits in with the rest of my workload. And if that means having to work evenings, weekends, that kind of thing, what it takes. But because when you take on a file that's pro bono, generally I found it's something that's you're interested about, or you feel a personal connection to it. It doesn't necessarily feel like work when you have to put in the extra time. So, but yeah, I mean, the entire practice of law is a juggling act anyway. So
that has been my experience so far. Christian, do you have something to add?
Yeah, I would just add, so Dana's example was, communicate with the team that you're working with and whether you're able to take that on or whether you're jammed at that particular time. There's another avenue of communication I think is important too, is if you are junior, if you are articling, then talk to your mentors, talk to your principals. You'd be surprised that the majority of lawyers in private practice would be supportive of having their junior work on these types of files. So communicate to your firm that this is something that's of interest to you, and you'll probably find some support there. But that's the most important piece is going back to the time management issue that Kathleen had raised, is communicate with your principal, communicate with your employer, the firm, that this is what you want to do and this is what you're doing, and certainly jump right into it, because some of the best experience I've had to date in my career certainly is the pro bono work.
Thank you.
And I think that the issue of managing your time also ties into making sure that you're ready to take the work. Like I found it, at least for me, it was easy to do pro bono work when I was working underneath somebody else, because I was able to do the bite-sized portions. And it took a little while for me to actually take these cases on my own accord. But at that point in time, I had a better sense as to how the law moved and how it felt and how you could apportion time. Because when you say, all right, I'm going to intervene on the Supreme Court for this case, you don't really have a sense as to what that is, like how to work out the logistics of finding, oh, I need an agent, or I should have an agent, and I got to do this motion and I got to do that. If you're a couple of years under the belt, those things, while they'll be new, they won't be from outer space. And so allowing yourself just to grow a little bit allows you to manage your time better, and then to do what Dana said, of spending a weekend thinking about whatever area of law is of interest to you. Because my experience is the same as Dana's. There'll be times at which you just sort of sit in the car and you start talking to yourself about administrative law, because it's important to whatever area, whatever case that you're doing. And then people look at you funny and they ask if you need help, and you say you're fine, but you really talk through whatever issue it is.
Thanks. I'll maybe stick with you, Sasha, because you talked about, I don't want to say stalking, but spending a lot of time on the Supreme Court website on Thursdays and seeing what might be of interest to you. Can you talk about how you find pro bono work, or how it finds you? How do you seek out the kind of files that you're interested in working on?
I guess pro bono work, for me at least, is either come through the Public Interest Law Center itself, in terms of just filling out a little form and throwing your name in, and suddenly you get pulled in through no real understanding of your own. But more proactively, at least, Like I've always watched the cases that got granted leave, which is a good aspect of what the Supreme Court does. Every other court is much more secretive about the cases that are going before it, which I don't think is the best, because sometimes you do want to have something to say. The Supreme Court, I think, is a bit more welcoming to interveners. So that is an aspect that I try and watch, to say, I look at this case and I find a case that I believe suits my area of interest and perhaps even my business development plan. Like I do a lot of administrative law. I make money doing administrative law. I'm interested in it. So doing cases in that area, I think are helpful for your clients to say, oh, well, Sasha's been in the Supreme Court on this. He must know what he's talking about, which is true. I do know what I'm talking about.
Always, yeah. How about you, Christian? You talked about Francophone cases being close to your heart. How do you seek out the opportunity to contribute to that?
Well, first of all, I'm just amazed by Sasha's modesty there. So that's quite remarkable. That work, it finds you in the sense that, to take it back, same thing as Sasha, if it wasn't for Public Interest Law Center, I wouldn't have had the benefit of working on the most recent pro bono case I worked on went to the Supreme Court here when it was in Winnipeg. And so that's a good place to start. They've kind of, I'd certainly say they're the go-to folks in this town if you want to get involved in pro bono work. Certainly sign up, get involved, reach out. They'll be able to help you, I'm certain, in that regard. And PILC is incredibly important to the legal landscape here in Manitoba, but on a national level. And all of you listening, I encourage you to support them wholeheartedly and reach out to them. Going back to the other point is, after you start doing these types of files and this type of work, you, for lack of a better term, run in certain circles with folks who do or equally engaged and equally interested in doing that type of work, and that work comes to you. As Sasha said, another thing too is keep in mind what's going on in the Supreme Court of Canada, because that's really indicative of where the court is leaning and what are issues of national interest. And so I would certainly echo that point as well. And unlike Sasha, I'm the first to admit that I largely don't know what I'm talking about, and which is not a bad thing for a lawyer, because it makes you second guess and
Don't
really,
buy the publicity. You should see him when he's not on Zoom. It's all just patting himself on the back.
Kathleen, do you have anything to add about seeking out pro bono work?
Yeah, I mean, PILC is where you would go. Always has interesting work going on, and always opportunities for that. I've actually found that even in my own practice, I've taken on pro bono work just by a client inquiry. If it's a matter that I'm interested in and I'm of the view that it's important and needs to be litigated, then I've made arrangements with people, with individual clients for things like that. So, I mean, that happens, I might have one or two files going at any given time, and often it's in matters where there's, might be a historical abuse case or something like that, where, in my view, it's something that's important to deal with, but the individual may not have the means to pursue it. So.
Thanks, Kathleen. Dana, anything to add on that point?
Yeah, I think for me, definitely being proactive too. So PILC will certainly come to you once they know that you're interested and you've filled out the sheet and everything. But the Lee file that Allison described at the outset is one where I was proactive. And if I know anything, it's that Byron Williams, who's the director of PILC, is a bit of a glutton for punishment. And so on that file, really, I was just talking to someone that I know, who I worked with when I clerked, who mentioned, this file that was going forward, and he thought that there needed to be a homelessness perspective, but hadn't been able to get a client together on his end. And I thought, you know what, I might have a way to make that happen. And I put in a call to Byron and said, if you can get a client together, then I'll do this with you pro bono. And within 24 hours, he had this amazing coalition of 4 clients lined up. And I think we had something like 2 weeks to get our intervention application done. And my sincere apologies again to Allison for that, because she got involved in that file as well. But I think if it's an important issue and there is a significant public interest component, and you're doing what Sasha does and keeping an eye out on what's going on, you can probably reach out and see if there's an interest on PILC's front. And then to echo Kathleen's point too, I think when you're in private practice, especially if you're at one of the bigger firms, you probably have a marketing person at the firm. And if you've taken on a file maybe through PILC or otherwise, and it's public and there's been a decision and you can market it in some way, just getting your name out there and putting out the areas that you've worked in and the interests that you have, chances are other work is going to start finding its way to you. And so like Kathleen, I've had the opportunity to take on pro bono files that have come about either through client inquiries or lawyers in other cities who know me from various files or whatever it may be, who have reached out and asked if I can take something on. So I think you can sort of create a bit of an opportunity for yourself too, once you feel ready to do that and start taking things on your own. I think the opportunity is there. I do labor and employment work, human rights work as part of my practice. And I often encourage juniors, if there's a really great file and the person just doesn't have a lot of money, maybe it's a really compelling human rights complaint, that I'll supervise them if they want to take it on at a reduced rate or a pro bono rate, because it's going to be good experience for them. And they're at a level where they're not working on commission and their time can be basically just written off entirely. So if something comes across your desk as a junior and you think you can make that pitch to someone who's a mentor or someone that you work with, just go talk to them, and chances are they'll be really happy to support you in that and be available for you to pick their brain and talk through a file. And then before you know it, you've got this great experience under your belt as a junior, and you can start taking on clients on your own who are going to pay you too. So it's kind of a win-win, I think.
Yeah, I do have another question sort of connected to that, but I should say first, for folks who are in the audience, as it were, scattered in front of screens across the nation, I'm sure if you have a question, please drop it in the chat and I'll bring it to the panel. I feel a bit selfish sitting here having this conversation, hugging all this conversation to myself. Dana, you talked about sort of people coming to you or juniors having things come across their desk. Can you talk about how you know what the right or maybe wrong kind of pro bono case to take on is, and how you determine the right kind of work or client? Oh, Robin, I'll just pause on that question. I'll ask it again. Hi, Robin, welcome. I'm just about to ask Dana to talk about knowing the right kind of pro bono case to take on, or maybe better knowing the wrong kind of pro bono case to not strap yourself to.
Yeah, I think that can be a bit tough, and probably lots of people can tell you about a time they made the wrong call. And for me, the first thing is some amount of self-reflection in terms of what am I interested in and what work excites me, and where do I want to learn more and do more work, and doing that process of self-reflection, and then how a file that has come across my desk fits into that is going to be an easier call to make. I usually, if Byron sends me an email, I probably get back to him way too soon, because I usually just immediately get just a little leap in my stomach, like, yes, this is going to be a super interesting file, I'm in. But that's because I've gone through that process of thinking about the type of work I want to be doing and what my interests are. And then I do ask questions that are more of kind of a business value thing, in terms of, am I going to be getting good experience? Is this a good opportunity for me in some way? And thinking through kind of the sell of why it makes sense from the firm's perspective for me to be doing that work. I do think you have to be careful, particularly, I think if stuff is coming from PILC, they've gone through the process of thinking about it and vetting it. And so, at that point, it's, do you have time and are you interested? If it's more of an individual inquiry, take some time to think it through. You want to make sure that you don't take on a pro bono client that's going to morph into something all consuming and more than you expected it to be. And I think many people who do pro bono work have, unfortunately had that experience. So really, like, listen to your spidey senses. Does anything feel a little bit off about it? Are there sort of clear limits on what you're being asked to do? Or is it kind of vague and indefinite and uncertain? Do a court docket search if just to see, has this person had other representation? Do they have 50 files where they're suing every lawyer in the province? The docket search will help. Even a Google search, sometimes will give you some information that maybe this person is going to be difficult or high maintenance, or isn't telling you the full story of what's going on. And so, do a little bit of thinking, research, talk to somebody, a mentor at your firm, or the head of your litigation group or whatever, as well, and make sure that it's something from their perspective that they would support and they don't see any issues with. So I think just doing some due diligence is going to help, and maybe just be mentally prepared for the potential that it could go off the rails, because that's also the nature of a litigation practice.
Very fair. Robin, do you have anything to add to that? And welcome. Thank you for joining us.
Yeah, for sure. Sorry for being late. Another obligation. And sorry, the question, can you just repeat the question?
I was just asking about how, especially as a junior lawyer, whether the pro bono case in front of you is the right kind of thing for you to take on, or whether it's something you should avoid for now.
Trust your gut, your spidey senses. And also, I think what the first thing that Dana said was it has to be something you're passionate about, right? An issue that you're wanting, you get fired up about, right? You see an injustice that you want to be looking to make some positive change. So it has to be, it has to click with you. It has to fit. You have to like the clients, right? I think that goes generally with any legal work you do. It's always better to work for people that you enjoy speaking to and working with, and just sort of, an issue that hits home with you. And also maybe if, working with others, I really enjoyed working as a team, with the Public Interest Law Center, and also Ronnie McKenzie and Kelby Lopke of Taylor McCaffrey. So I would have not, I don't know if I would have lasted, right? If I had only been trying to do a case solely pro bono. And it's that team approach that's the best, right? Bouncing ideas, the creative thinking, the collaborating, that's really rewarding. So for me, I really enjoy working on a pro bono case and seeing if it's also going to be, working with others as part of a team.
Thanks for that, Robin. Anybody have anything to add on to that question, Kathleen?
Yeah, I would also say that one thing to think about is your capacity and experience on the given subject matter, or the the jurisdiction, the venue, whether is it a federal court or Queen's Bench, that kind of thing, because you want to know ahead of time whether this is something that you can take on yourself, or whether you're going to need to be part of a team, because you may be junior and you don't have a lot of experience in that area or in that court. So you want to make sure that the workload is going to be something that you can either take on your own, or if that you've got a group together that can help you out, because you don't want to end up taking on and then feeling like you're drowning in the work and you don't have anywhere to go, because you've done that checking ahead of time.
Thanks, Kathleen. Sasha, Christian, anything to add? I have more questions if you don't have anything to add to that one. You're hiding. Okay. I guess I think it's one thing to sort of talk about the logistics of doing public interest work, but I think what really excites people is the stories of the kind of work that you get to do. So I'm wondering if anyone has any exciting or interesting stories about the kind of files that you've been able to take on. Sasha, I can't tell if you're laughing at the question or in general, so I'll ask you to answer first.
I'm always laughing because I don't know if any of my stories are just generally interesting at all. I find them interesting. That's because I don't know, I think quite highly of myself or something, perhaps. But I mean, it is, in terms of the stories, like they do give you, or at least the pro bono files, they do give you things that can stick with you. Like, so, and I'll draw this distinction. Pro bono, sometimes people see it as just mainly free, like you work for nothing. I have some level of pride of trying to introduce the concept of low bono files, which is a term that I'm going to take credit for it because I'm patting myself on the back a lot these days. So in a case called Niebusch and Magard, a federal court case, I was fighting over a First Nations failure to call an election for the position of chief. And my client, Ms. Niebusch, came along and said, you know, this is not right. Could you do something? And I said, like, look, I got a house, got a car, I got kids, you know, like this is interesting, but I need to make some money too. But when I heard her case, it was compelling. So we agreed to work on a flat rate to say, I'm not going to charge you over this. The money that she gave me was just unbelievably not enough of what the actual litigation was, but for her was significant. And to me, gave me, it allowed her to look at me as her lawyer, not as something that you get for free, but something that she invested in. So it allowed her to look at me differently. And for me to look at her in the same way, that we're in this together, that there is some money there. So that I think helped the relationship, because I didn't want anybody to be taking this file and then making my life miserable. But during that, like we had wonderful sort of, like I had to drive out to Brandon to meet her halfway because she was in Saskatchewan. We met at a gas station and we signed affidavits, and I drove all the way back to, I mean, this is the day before, well, this is the day I don't understand computers. I still don't understand computers, but you know, it was nice meeting this woman and her relatives at a gas station on Highway 1 in Brandon. Those are just nice little stories you accumulate. And then ultimately it led to Justice Mandaman giving a decision about, you know, Sasha's working low bono, and they awarded some level of costs against the other side, arising out of a settlement, which was really, really odd. But those are the little victories that you remember. And I still think very fondly of Ms. Niebusch, even though I haven't, you know, talked to her in a gazillion years. But those stories aren't things, as you can tell, will, you know, excite people, but they're the stories that you tell yourself, how you say, you know, well, it actually does matter. It is interesting. It's interesting to you. And don't be afraid to at least, if you don't want to articulate it to others, to remember those stories. So when then life is going sideways, you can remember why you do it in the first place.
Thanks, Sasha. Anybody else have a story that stuck with them that reminds them that that this work matters?
Maybe, can you guys hear me?
Yes.
Yeah,
very well.
okay. Yeah, maybe I'll just share my experience for my case. And I have the benefit of a lot of cute babies in my case. So I get Christmas cards and pictures of the babies. So I have to tell you, it is the best, best part of doing that case. I get updates on how their kids are doing. So because I represented parents, right, who had children by way of assisted reproduction, it was so personal, right? There's nothing more personal than being a parent and wanting to be legally recognized as a parent to your own child, right? So it was such an intimate relationship we developed with those clients that really is long standing. You know, and so it was really just seeing how the law can affect people's lives, and but I don't know that you get to see in many other aspects sometimes. And then how it affects, you know, other people's lives as well. So, but I have to say the benefit is just the personal nature of it and the personal connection you often develop with clients in the pro bono setting, and they're so appreciative of what you do. You're like, why aren't all my clients this appreciative, right? Because you're doing this for them, you know, on a pro bono basis, and they've been feeling whatever wrong or discrimination they faced and haven't really been successful in finding a lot of uptake on people to help them. So it's amazing, I think, for the clients and how appreciative they are of your work, which is always an added bonus.
I would add to that too. I think, you know, these are public interest cases. So they're public interest cases because they matter broadly to the public. There's some underlying significant public interest at stake. And so that often means that they're in the public eye and they're being reported on by media and they're being talked about. And it's really rewarding to be a part of something that is part of the public dialogue and conversation. And so a case that I'm working on now with PILC is for the Assembly of Manitoba Chiefs and involves legislation passed by the provincial government to extinguish litigation and all causes of action related to child welfare funds that the government had kept for its own use over a 14-15 year period, and this new legislation comes in and says, well, you can't sue anybody over this, sorry. The Assembly of Manitoba Chiefs is an amazing client, and they are, along with many of PILC's clients, also looking at the communications side of litigation, which is not something you always do in private practice, and getting that out in the public dialogue. And there's something really cool as a lawyer, as you know, when the day your notice of application is filed, that we had it planned so that the minute the legislation was passed, we would be ready to file, and it was passed at some ungodly hour in the middle of the night, and Chris Clausen at PILC was on top of it somehow, and we were out, not me because I was asleep, but Chris was like ready to go and get it filed, and then ANC was, you know, issuing press releases and telling the public what they were up to, and it feels really rewarding and meaningful to be part of something that is in the public interest and that a conversation is happening about. And you know, my private practice clients would often prefer to not be in the public conversation. So it's just a different experience, and chances are you might have more stories that you can tell if you're doing that kind of work, just because part of it is often that communications piece as well. And so it's just a lot more public and discussed than a lot of my very interesting but much more quiet private practice files.
Yeah, thank you. Kathleen, Christian, any tales of rewarding and meaningful work that you've taken on?
Yeah, you know, law is on the whole, it's pretty incremental. You know, I always joke that I truck and trade in the misery of others on a daily basis, and you know, company A is suing company B, and you're thinking, well, you know, you're doing a good job, you're interested, it is interesting work, you enjoy your clients, but you're not really changing the dial or moving the dial much. And when you get involved in some of these cases, in particular the larger ones, as Dana said, they're public interest files because necessarily there's a vast public interest that's at play. And in the case that I was involved with the Conseil Scolaire, it was the culmination of 10 years of litigation from a parents group in British Columbia, where they're trying to get schools for their kids. And the provincial government in BC essentially said, look, we know that there's assimilation happening, but building these new schools will maybe only delay assimilation. So at best, that's what's going to happen. So we're just not going to give you access to equal institutions. And it was the longest trial in the history of, I think, British Columbia. The trial decision was some 1,600 pages. I wasn't involved in that. The Court of Appeal decision was quite long as well, 300 pages. And when it gets to the Supreme Court of Canada, and they come up with their decision that overturns the trial decision, it's something huge. And just to be part of that is quite exceptional. And you know that these parents in this community in BC has been fighting for the better part of 10 years. And I believe we're talking about legal fees in the realm of $15 million was spent to force the government to recognize that it had an obligation to these children. And now you're going to have generations of kids in BC who are going to have access to equal education in the French language. To me, that's quite special.
Yeah, that is quite special. Kathleen, anything special to share?
Well, so my colleague Andrew Buck and I worked on a project for Barrier-Free Manitoba. So, and that was helping them advocate on behalf of people in Manitoba who live with disabilities or barriers to accessibility to get standards under the Accessibility for Manitobans Act, sort of to craft what they were going to be, and provide advice to on those issues. And so it's really rewarding to be able to help out not just an organization, but in providing that advice. We're helping untold numbers of Manitobans, right, who may have visible barriers and invisible barriers to moving throughout the world in their daily lives. So that's just something that would never come up as an opportunity private practice. So
yeah, that sounds really rewarding. I should again remind folks that if you have any questions, I have a list. I could keep you here all day, which I won't. But if folks who are tuning in have any questions, so please flip them into the chat so that I can bring them to the panel. I think we spoke earlier about, so everyone on the panel is in private practice, and I'm wondering if you can speak a little bit more about firm support. So how your firms supported you in taking on public interest work or pro bono work, if they did, and how they did.
I'm going to jump in now just because I have to duck out early. So
yeah.
So I've always found that firms I've worked for have been supportive of this kind of work. And I think just in general, I think the general public would be surprised at the extent to which lawyers give of their time outside of private practice. So I don't know, I don't have a single colleague who doesn't volunteer their time on a board, whether it's outside of the legal profession or within, law society work or bar association work. So that type of thing is encouraged. And, it's always been my experience that it's been encouraged, because I don't, people are taking on pro bono, they're being reasonable about it. We understand we have other obligations, and they are being put to the side, but this is an added benefit. Not only does it help you as a lawyer, give you experience, helps people who wouldn't be able to get the help otherwise, but from the firm's perspective, as Dana was saying, there are marketing people, and if you have your name on a decision that may attract more public attention than the average case, that doesn't hurt the firm either, right? So I've always found it's, it hasn't been an issue getting support from within the firm.
Has that been everyone's experience? Robin?
Yeah, absolutely. I mean, sometimes I think they didn't realize how much work I was doing on this case, but in the end, no, that's just as an aside. Yeah, I think that there's a long history, at least at Taylor McCaffrey, right, of pro bono work, as there is at other large firms. Firms have an obligation to give back to the community as well, like just globally. And I think that's acknowledged now, and I haven't heard of any other lawyers being discouraged from taking on a pro bono case. But I think you have to be upfront with the firm, right? Like before you take it on, go to whoever, depending on what stage of your career you're at. If I was a partner when I took it on, so I mean, I just did. I didn't really talk to anyone. Maybe I should have, but but if you're an associate, talk to whoever your mentor or a managing partner, just to make sure that they're understanding that it will take a portion of your time. And I would be very surprised if anyone would discourage you from doing that. Yeah, so I've had nothing but support and throughout the case, and really, and because, as Kathleen said, it's good for the firm's image as well. It's good for, not only is it the right thing to give back to the community on a firm level as well, it also is helps with the marketing as well.
Thanks, Robin. Dana?
Yeah, I would maybe just, I think it would be really funny to just pop up and say that no, my firm was terrible.
Sure.
Obviously, we're all here, and I think what you see on this panel is that there's representation of all the large firms because there's a history of pro bono involvement. I've also had experience working at a smaller litigation firm in Ontario, and so I think if you're in your early years of your career, or you're a student and you're heading to a firm that's maybe one of the smaller firms or not one of the firms that's kind of represented on this panel, then you're an advocate, and if there's a file that you want to take on a pro bono basis, and you're not sure if that's something your firm would support, then think about how you would advocate for it and going to your mentor or the person at the firm that you feel you need to talk to about it, and think through some of the things that we've talked about today, like why it would be a good experience for you in terms of the type of work you're going to be able to do. Maybe it's a chance to take on a little bit more of a lead role in court and do that because it's a pro bono file, and you're able to sort of take that step in your career. Maybe you do think that it's going to result in a decision or some kind of public discussion that can be marketed and can bring in other paying work to the firm, those kinds of things. Like I think there is often a business case to be made, and ways that you can kind of sell it to the firm if you're not sure, if they don't have as long of a history or as visible a history of supporting that kind of work. And so I do think there are ways that you can pitch it, I guess, and have those conversations. For me, it was pretty short when I went to our head of litigation, Bernice, and said, I want to do that. First, she thought that Pilk was trying to like poach me and had offered me a job, because I think I came in and was like, Pilk has approached me with an opportunity. And after she got over that mini heart attack, the pro bono file didn't seem like that big of a deal. But also she was very quick to say, yes, of course, and make sure that you're still doing what you need to do within the firm, but otherwise we support you. And I think that will be the case even at smaller firms, if you approach it as an advocate for yourself in the file.
Thanks, Dana. We do have a question from the audience about whether this advice or information would change for articling students and young lawyers at smaller firms. So Dana, you did touch on that, but if anybody else has anything to add in terms of taking on opportunities while articling or as a lawyer at a smaller firm.
I really can't speak about a smaller firm. Well, let me. I think what Dana touched upon applies to that question. As far as an articling student, it's the same. You're quite early in your career, but if there's something there that is genuinely of significant interest to you, you advocate for it, you ask, you inquire, you communicate. And as Dana said, no one's popping up saying that their firm is horrible and frowns on this stuff. That they don't. I'd say I'm certain that confidently that the majority, if not all, firms are supportive of this. And as Kathleen said, aside from this panel, most of the people I know in the practice of law give a significant amount of their time. It doesn't necessarily have to be pro bono files, but they're out there in the community. So the profession, I think, is very open to giving time. And so if that's what you want to do, you communicate and you ask for it.
Thank you. We have another really interesting question from a person tuning in who asked, is there a role in pro bono work or public interest work for lawyers who do not enjoy litigation? So Kathleen, who had to step out, mentioned working on a pro bono file with a lawyer who's not a litigator. Have any of you had experience working with folks who are not litigators, and can you speak to the sort of contributions that non-litigators can make?
I'm really struggling with that. I don't know what kind of contribution non-litigators can make. So. No, all deference to my colleagues and friends. No, I'm certain there is, and I think there's an opportunity. You know, if you're not a litigator and you want to help at on a community level, you can go to the Legal Help Center. I've given time there, and I've seen senior counsel there who are not litigators, and that's real pro bono work. And there's nothing wrong with doing that, and it's a good place to go. And so you don't necessarily have to be a litigator. Legal Help Center, you deal with a whole bunch of questions of people coming in, they need help, and that isn't always tied to litigation. So there's one avenue I think that you can explore.
Thanks. Sasha, go ahead.
And just even like, again, if you don't litigate because you're smarter than all of us, like if you're a solicitor, the way that you analyze problems and think through, you know, solutions is really valuable to a lot of boards that so many boards struggle and they desire having lawyers on it. So trying to find a board that's of interest to you, again, in one sense, can play an important role if you're a solicitor who wants to, you know, increase your profile in the community, because those people you sit on a board with could be the next file on whatever solicitors do. I don't know, papers and stamps and the like, money. I just know they're richer. But you do have the ability to assist boards in doing work, important public interest work, but not being as attention seeking as like me and Dana and Robin and Christian, you know, like you can do probably more in the background by assisting on boards because of the way you think. So do that if you want, and go take a hard look at those boards around.
Yeah, maybe I'll jump into like for sure. Also just public education, sometimes just general, you'll find a lot of, even if you don't want to sit on a board or you know, do the clinic at the Legal Help Center, there's lots of other opportunities for the Legal Help Center to do education seminars, or sometimes boards will want information or education. So I've done I would say, like, in addition to litigation, I've done some significant education efforts to policy stakeholders or in the area that I'm involved in, which can also be a great way to educate, raise awareness of a specific area of law or issue that you think needs to be addressed. Just sort of another avenue. Oops.
Thanks, Robin. Just building on that question again from the audience, you spoke a little bit about other ways that you can be involved in pro bono work. Can folks speak about different ways you've been involved in pro bono or public interest work? There's a list in the question. So full-on litigation, research, informal consultation in meetings, expert advice on specific issues to folks' staff. Anything to add there?
I think that's a really good list. Probably covers off a lot of what there is. I mean, yeah, I think whether it's through PILC or in your own practice, there's going to be different types of things that you can do, and it's not always going to be, you know, filing papers and going to court or doing an intervention or that kind of thing. So sometimes it's, you know, providing an opinion on an issue that has a public interest component, and maybe that opinion leads to litigation or it doesn't, but it not everything you write opinions on it is going to be for the purpose of litigation necessarily. You know, I have developed a bit of a practice in representing sexual assault complainants, and I'm involved in a program through Victim Services where I do what Sasha would call kind of low bono or legal aid rate work in the criminal process. But because of that, other work has come my way that relates to those kinds of issues. And I sometimes take things on if it involves a workplace investigation or a regulatory investigation where those issues are involved and the complainant needs independent advice. And so, I'm very much in the background, especially if it's an investigation process, but providing advice and guidance to someone who is dealing with that and going through that process. So I think there's all manner of things, and research for sure in your early years. And I think PILC is often quite keen to get students or early career lawyers involved in researching issues and providing that kind of research support and analysis. Or I think that the project that Kathleen mentioned, that was more of a sort of guidance, advice, assessment, working with a not-for-profit organization and helping them shape submissions that are being made to government maybe, or there's a whole realm of legal work that even people who like to be the center of attention, as Sasha just said, like all of us, we'd all love to be up on our feet in court, all the time. But the reality is a large area of litigation that isn't actually standing in court and litigating. There's a lot of other things that you can do to support and is just as valuable as sort of the end product if it does happen to be a court case.
Thanks, Dana. Anyone have anything else to add in terms of non-litigation contributions to public interest or pro bono work? No, Shasta's shaking his head. Let me see if there's any more questions here. No. So I suppose, I think we're sort of approaching the end of our time together, unfortunately. And so I'm wondering if folks would be interested in making the pitch. So what can early career lawyers, articling students, early career lawyers, students gain from being involved in public interest work and working with organizations like PILC to contribute to the legal profession?
Maybe I think it's a great way to learn, like even like tangible skills, right? You get to probably do things that maybe you wouldn't get to do, right, on a regular file. So you do learn a lot and grow as a lawyer, and develop skills. And but mostly it's learning from other lawyers if you're working as a team and doing something really rewarding. What we do every day is, I enjoy my work, but of course it's those cases off and on that really inspire you, right? To see that you helped one or maybe a group of people. So it's really inspiring but also practical in terms of being able to give you some good practice on some skills and really learning from others.
Thanks, Robin.
I would echo that. It's really you allow yourself to get exposed to an area of practice or stage of litigation that you might not get as a younger lawyer, and especially if you work with a team. As I said earlier, you get to watch these other lawyers, how they work a file, and that's invaluable. It's called the practice of law for a reason. You learn by doing, and the more you're exposed to very varied lawyers and how they practice law, I think you can only benefit from that. Even if it's bad lawyers, you learn what not to do. But by and large, you learn from very exceptional lawyers when you work in a team.
Was he pointing at me, or is that just how Zoom works? Bad lawyer. Okay, me and Monen are gonna have a fight after this.
I have to say as well, I forgot to say, Allison, who's on here, right, is like the best writer. Okay, she wrote. When you see good legal writing, I was like, when I say you learn from others in a team, you really do. Like I saw some brilliant legal writing that I can't do, and it really did improve sort of me reflecting on my skills, and I learned a lot from other people and just seeing other styles, right? Because often as a lawyer, we don't really work, unfortunately, like in family law, I work I'm the only works on the file, right? At my level as a partner, I don't really work many with other people in that environment. So it's just such a great opportunity to collaborate and see also where your skills lack when you see how other people do things better.
I have 2 points to make. I would pick up on a point that Kathleen made earlier, just in terms of these files often having more of a luxury of time because you don't have that push to be efficient billable hour pressure. And so I've found, much like Robin was just saying, the opportunity to work with a team at PILC and really take time to work through a case theory and a strategy in a way that I'm not necessarily doing in my regular private practice, and see how they approach it and the types of public interest strategizing that goes on as part of that team is you learn a lot from it, and it's really, really valuable. And then because you've learned those skills, you can take them into your private practice, and you'll be more efficient at thinking through some of those theory and strategy questions from that experience. The other point that I would make is I don't think it's even so much the pitch of you should do it for students and early career lawyers as it is you can do it. I think a lot of times students and newer lawyers don't believe that, and you should. It's your professional obligation to make sure that you're competent and that you have the capacity. But chances are you do. If you're interested, you have something to offer. It may not be taking the lead and arguing it at the Supreme Court like Christian did, but you can bring value, and you can do it, and you do have skills. A lot of you have been involved at the Legal Help Center or the Legal Aid Clinic at the law school, or have done moots and have practical experience and have done a lot. Just because private practice works in a way where you aren't necessarily running things yourself a lot of the time, and that's probably a good thing, so that you're getting lots of opportunity to learn, but that doesn't mean you can't do it. So part of it is, I think, believe in yourself, put yourself out there, express an interest to do it. And even if it's scary, if somebody comes to you and asks for help, if you get the call from PILC, take the leap. And as Christian said, that's how you're going to learn. And I really believe in all of you that you can do it. So that's my pitch to you, to believe in yourselves.
I'm just going to talk about myself. Dana's just going to give the inspiration. I'm just going to center it back on me again.
Okay.
One of the fun things about working with the Public Interest Law Center over the years is helping them get ready for Supreme Court interventions, because then you can play the ordinary Supreme Court judge as they get ready for moot arguments, and you get to poke at them, and you get to attack their various written briefs, all in a way that allows if you're on the receiving end, the ability to say, that's a fair comment, or I don't think that's appropriate. I don't like that. I don't think that comment really rings true. But you're able to then get an assessment as to how you can advocate in a way that makes you feel comfortable in your own skin. Like the words that can fit in my mouth won't fit in other people's mouths. Because you need to feel as though they're your own, as opposed to somebody else's. And one of the things that you start to learn, and I learned it when I'm sort of helping people getting ready, is everyone has their own style, and you see that like the Gabor Lukács intervention or the carbon tax intervention. You see people articulate things in a way that isn't your own, but it's more than equally good. Like, it's superior than what you could do, because they've really thought through the issues. And one of the things that has happened over the years, I've been fortunate to help PILC lawyers get ready for those Supreme Court cases, or in the case of Allison Fenske, when she was at the firm, like, we would do cases together. And it is it's nice to see that, because you learn something as well, to say, oh, that's how they put that in, and you can really draw something from it. So I said this was going to be about me, so It is, but it isn't at the same time.
It was enough about you. I think that
Yeah,
counts.
I think that's good. That's good. That's good.
Yeah.
Sasha
Right.
Paul, by the way, sorry.
Does anybody else have anything to add on that point, or any points? Anything to pitch or promote?
Can we go back to war stories?
Do you have one?
You know what? I forgot about this war story when I was arguing the Omar Khadr case. Like, again, justice is great. Like, I really love that case, but there are points at which you understand, you're developing your own skills. I remember arguing that intervention, and I remember Justice LaBelle. I still remember, it's like 10 years on. He asked me a question, and he knew that he rung me up. And the best part, again, I'm doing this for free. I'm getting beaten up on national television, CPAC. But national television, and you could see Justice LaBelle, lean back in his seat and sort of squint his eyes, then look around to his colleagues. Those are great stories. I don't get rung up like that when I'm getting paid, but for public interest files, I get rung up like that all the time. It's grand.
Thank you, Sasha. That's a very encouraging note to end on. The prospect of getting beat up by the Supreme Court is not the worst. Thank you all so much for volunteering your. Oh, Christian, do you have something to say? Sorry, I just see you went off mute.
I was just going to comment. Obviously, it didn't hurt your humility, Sasha. You've survived that and you've thrived. So it's good to see. And let that be a lesson to everyone that you can go to court and a judge may disagree with you and quite forcefully, and you live to tell. You live to tell about it later. So it's very.
And you
good.
realize the judges were wrong.
That's what I always tell myself, Sasha. I'm like, well, one day they'll realize how wrong they were.
Exactly. I don't know how this became about me again, but I'm Sasha Paul, and okay, shut it up.
Okay, I'm gonna close this off. Thank you, Christian, for the educational twist on Sasha's story there. And thank you all for volunteering your time today. This was a really, I think, interesting and valuable conversation to remind us that we should pursue opportunity to practice public interest law, and that we can, as Dana said. So I'll throw it back to Allison just to close off, and thank you all again.
Thanks, Jim. And yeah, thank you everyone for sharing your time and your experience, your insights. We're really grateful for your contributions, not only to PILC's Pro Bono project, but in this event to just having this conversation about the public interest and all of the contributions that you make in terms of just like really important progressive social change. So thank you for that. To those that were listening, I hope this was a valuable event. We hope this is just one of a series of conversations about the public interest work and how it can be done and to make it more impactful for people and know that they can do that work. So thank you all for joining in. This has been a really great experience. And yeah, look for an email from me in the next few days as a wrap up to this event with a reminder that you can get some CPD credits for attending this event. And also we'll probably have a survey to send out. So for anyone whose interest is piqued in public interest work, the lawyers at the Public Interest Law Center are always happy to chat about that. Feel free to message me directly. My email was in the registration link, and always happy to have those conversations and to welcome new lawyers into that work. So thank you again for everyone for attending, and to our panelists and our fantastic moderator. So thanks.